What are the treaty principles and what do you need to know to engage in the debate? Kia ora e hoa ma, I'm Kiri Prentice and you're watching the Ahe series brought to you by Māori Minds. If you're new here, don't forget to check out the intro and foundational videos for the series. You can also find downloadable resources in the video description. For more, visit MaoriMinds.com. Let's begin our wānanga. In today's video, we will be answering the following key questions about the treaty principles. Why were they created? How are Te Tiriti and the treaty different? What context is needed to understand? Where did they come from? Who decides what they are? What are the treaty principles? How do they show up in law? Why are they criticised? And then we will be going over some Wānanga prompts. Why were they created? The treaty principles were created to honour the intent of Te Tiriti and the treaty, signed in 1840, while addressing contemporary issues. The significant differences between the texts made literal interpretation difficult. The principles were developed as a way to work around these differences and ensure the intent of both Te Tiriti and the treaty were upheld and could be applied effectively to modern issues. How are Te Tiriti and the treaty different? The key point of contention in Te Tiriti and the treaty relates to Articles 1 and 2. In Article 1 of Te Tiriti, Māori grant kāwanatanga, government or governance, to the Crown, whereas in the treaty it is said that Māori ceded their sovereignty. And these terms obviously have very different meanings. In the 1830s, as British settlement grew in Aotearoa, New Zealand, concerns around the lawlessness of settlers and the need for governance increased. While New Zealand was recognised as a sovereign state, Britain needed to assert their sovereignty in order to establish legitimate colonial rule over their British subjects. In 1839, Lord Normanby, the British colonial secretary, instructed Captain Hobson to establish British sovereignty in New Zealand. Normanby emphasised that for the Queen to offer legal protection and governance, Māori needed to acknowledge British sovereignty. Hobson was tasked with negotiating the treaty. So over time, the meaning of the Crown, state and sovereignty have all evolved. Initially, the Crown referred to the sovereign head of state, the monarch. Today, the Crown also includes government, which is made up of the executive, which is the Prime Minister and the Cabinet, legislature or Parliament, where they make laws, and the judiciary, the courts. Additionally, there are Crown entities such as state-owned enterprises like the Met Service and public service agencies like Te Puni Kōkiri, the Ministry of Māori Development. Now, Article 2 of Te Tiriti guaranteed the protection of Māori tino Rangatiratanga over their whenua, lands, their kāinga, dwellings or villages, and taonga, their treasures. Tino Rangatiratanga denotes the absolute chiefly authority and leadership. Sometimes it is translated as self-determination or sovereignty. In contrast, the treaty guaranteed the full, exclusive and undisturbed possession of Māori lands, estates, fisheries, and other properties. So tino Rangatiratanga, chiefly authority, is not the same as property rights. What context is needed to truly understand? To truly grasp the differences between Te Tiriti and the treaty and why the treaty principles were created, you need to understand the full context. And this includes He Whakaputanga from 1835, as well as the complete text of both Te Tiriti and the treaty, including the preamble. He Whakaputanga and Te Whakamininga. Now, in 1835, the rangatira or chiefs that signed He Whakaputanga were asserting their authority and independence as part of Te Whakamininga, the Confederation, and they used terms like Rangatiratanga, their chiefly authority, leadership or independence, Kingitanga, which means sovereignty or kingship, mana, their authority, control, power. They did this to express their authority, independence and autonomy. They made it clear that they held the exclusive right to make laws, their ture, and to establish kāwanatanga, government or governance, within Aotearoa, New Zealand. This declaration of independence was formally acknowledged by King William IV in 1836. These concepts were foundational to rangatira's understanding of their authority, and those rangatira were very well aware of the distinction between tino rangatiratanga and kingitanga and kāwanatanga. The entire text. The preamble in Te Tiriti and the treaty outlined the Queen's desire to establish government in New Zealand and to protect Māori interests and rangatiratanga, setting the foundation for the relationship between Māori rangatira and the Queen. In Article 1 of Te Tiriti, Māori granted kāwanatanga to the Crown, while in the treaty they ceded sovereignty to the Crown. Article 2 of Te Tiriti guaranteed protection of Māori tino rangatiratanga, their absolute chiefly authority over their lands, villages and taonga, or treasures, while the treaty ensured that Māori had full undisturbed possession over their property. Article 3 was much the same in both the Māori and English texts. It promised that the Queen would extend to Māori the same rights and protections as British subjects, ensuring equality and access to the rights of citizenship. The fourth article was a verbal agreement added to Te Tiriti, assuring the protection of various religious beliefs, including the Church of England, Wesleyans, Roman Catholics, and Māori customs. So many scholars regard it as just one of several verbal commitments or agreements that were made outside of the formal texts of Te Tiriti and the treaty. It is not recognised by Parliament or the Waitangi Tribunal, but it has been referenced in national policy, such as Whakamaua, the Māori Health Action Plan for 2020 to 2025. Where did they come from? The treaty principles emerged after 1975 with the establishment through the Waitangi Tribunal Act of the Waitangi Tribunal, which is a permanent commission of inquiry that investigates alleged breaches of Te Tiriti and the treaty. The principles were later defined by the courts and by the Waitangi Tribunal. Who decides what they are? The Waitangi Tribunal plays a major role in articulating the principles. Through its hearings and reports, it investigates claims made by Māori regarding alleged breaches in Te Tiriti and the treaty. And while the tribunal cannot compel the government to take action, its findings shape how the principles are interpreted and applied. Courts also play a part in determining what the principles are. For example, in 1987 Lands case, the courts ruled that the Crown must act in accordance with the principles of the treaty, further solidifying the principles in New Zealand law. What are the actual treaty principles? The treaty principles have evolved over time, with many emerging since 1975. Early principles such as partnership and active protection have been foundational in guiding the relationships between Crown and Māori. Other key principles include equity, equal treatment, redress, informed decision-making, self-determination, right to development, mutual benefit, options, and exchange. In 1988, the Royal Commission on Social Policy outlined three core principles: partnership, protection, and participation, commonly referred to as the 3 Ps. In 2001, the Waitangi Tribunal report Y692 addressed the closure of the Napier Hospital in the 1990s and its impact on ahuriri Māori. So the report highlighted 4 treaty principles: active protection, partnership, equity, and options that are crucial to ensuring equitable health outcomes for Māori. In 2019, the pre-publication version of the Hauora report on Stage 1 of the Health Services and Outcomes kaupapa, Y2575 claim, highlighted the same principles of active protection, partnership, equity, and options. And it was this particular set of principles that were integrated into national health documents like Whakamaua, Māori Health Action Plan. How did they show up in the law? The treaty principles were first articulated in the late 1970s and early 1980s, as the Waitangi Tribunal began investigating alleged breaches of Te Tiriti and the treaty, and recommending ways to address them. By 1984, the government started incorporating references to the treaty into legislation, often through treaty clauses or treaty sections. For example, in Section 7 of the State-Owned Enterprises Act of 1986, It says that nothing in this Act shall permit the Crown to act in a manner that is inconsistent with the principles of the Treaty of Waitangi. Section 4 of the Conservation Act of 1987 says, "This Act shall be interpreted and administered as to give effect to the principles of the Treaty of Waitangi." Section 8 of the Resource Management Act of 1991 says, "Decision-making must take into account the principles of the Treaty of Waitangi." By the 1990s, treaty references had become well established in law and were widely accepted as central to the Crown's obligations under the treaty. Section 6 of the Paiora Healthy Futures Act of 2022 outlines the Crown's intent to give effect to the principles of the Treaty of Waitangi. Give effect is a strong legal directive requiring active implementation rather than mere consideration, acknowledgement or commitment. Why are they criticised? Overshadow original texts. Some legislation and policy refer only to the treaty principles without acknowledging the original text of Te Tiriti or the treaty, diminishing their significance. So this approach can strip Te Tiriti of its historical and legal context. Academics like Heather Kame argue that the original text should be central. The critical treaty analysis tool that she developed with her colleagues actually excludes the principles altogether to emphasise the actual wording and intent of Te Tiriti. Reinterpreting Te Tiriti's intent. Some argue that the treaty principles have overshadowed the treaty's original intent, shifting focus from Māori tino Rangatiratanga to Crown-defined interpretations. So rather than upholding the preamble and articles, the Crown has used principles to define its obligations, in effect weakening Māori tino Rangatiratanga. As Mutu in 2019 suggests, this could be seen as an attempt to bypass the original treaty. The principles could potentially contradict the original text and intent of Te Tiriti and the treaty. For example, if the Treaty Principles Bill were successful and were introduced into law, it would conflict with Te Tiriti and the treaty by introducing principles that differ from the original texts. The bill ignores the central relationship between the Queen or the Crown in rangatira Māori, and it omits the concept of tino Rangatiratanga, which is fundamental to Te Tiriti's meaning. Vague and inconsistently interpreted. Treaty clauses reference the principles in broad terms without specifying which ones. There is no single codified framework for the treaty principles, leaving interpretation open to debate. Now, some argue that the lack of clarity allows for misinterpretation, an argument that underpinned the Treaty Principles Bill. Now, the bill sought to redefine the principles, overriding decades of legal rulings, something we call jurisprudence. However, detailed explanations of the principles along with relevant case law can be found in Waitangi Tribunal reports, court rulings, and through a simple online search. Crown control. The principles are determined by the Crown. They are determined by the courts and the Waitangi Tribunal, which is a Crown-appointed body. Now, while Māori can participate in kāwanatanga and they can participate in the Waitangi Tribunal, as is their right guaranteed through Article 3 of the treaty, this differs significantly from exercising their rangatiratanga on behalf of hapu. The principles are not determined by rangatira or Māori entities with a Māori mandate, meaning the Crown controls their definition and their application, limiting Māori tino rangatiratanga. Questionable effectiveness. While treaty principles are embedded in the law and policy, they have not prevented ongoing treaty breaches or Waitangi Tribunal claims. And the tangible benefits for Māori remain limited. They have yet to effectively address inequities experienced by Māori or ensure that the Crown can fully meet its tiriti obligations. The Waitangi Tribunal's Y2575 Stage 1 report found that the Crown has not upheld its treaty obligations in health, leading to persistent health inequities for Māori. What are the treaty principles? The treaty principles were created to honour the intent of Te Tiriti and the treaty, address translation differences and guide their modern application. The key differences are in Articles 1 and 2. In Article 1, Te Tiriti grants kāwanatanga to the Crown. In the treaty, it said that Māori ceded their sovereignty. Article 2 guaranteed Māori tino Rangatiratanga of their land, dwellings and taonga, whereas in the treaty it framed this more in terms of property rights. To fully understand the treaty principles, you must consider He Whakaputanga from 1835 and the complete text of both Te Tiriti and the treaty, including the preamble. The treaty principles emerged after 1975 with the establishment of the Waitangi Tribunal and were later defined by the courts and the tribunal. There are many treaty principles, including mutual benefit, the 3 Ps of partnership, protection and participation. And in the health context, the ones that are particularly important are partnership, active protection, equity and options. Since 1984, treaty principles have been incorporated into law in treaty clauses in acts like the Resource Management Act of 1991 and the Paiora Healthy Futures Act of 2022. They are criticised for overshadowing the original texts, reinterpreting Te Tiriti's intent, being vague and inconsistent, being Crown-controlled and lacking effectiveness. Want to learn more? Check out this video on Māori Minds. Be sure to watch the next video in the series, Wānanga Prompts. After I go through them, pause the video and as a group choose the Wānanga prompt that you want to focus on today. If you haven't already, print the downloadable worksheets. The link is in the description. Wānanga Prompt 1. No more 3 Ps. In the healthcare setting, the original 3 Ps of partnership, protection and participation have been superseded by the principles of partnership, active protection, equity and options. Reflect on why participation has been omitted and why protection is now framed as active protection. Wānanga Prompt 2, Treaty Principles Bill. What do you think the impact of the debate around the Treaty Principles Bill has been? Wānanga Prompt 3, Treaty Explanation. If a relative or a close friend from overseas asked you to explain Te Tiriti or Waitangi, how would you go about this? So those are our 3 Wānanga prompts for today. Choose the right one for you. Have a wonderful Wānanga. Do you have any final words, Cricket? Say ka kite. Ka kite.